And that is exactly what we're dealing with. So the statute is unmistakable. And judges have given decisions lawyers have had big fights with. Now, as someone who teaches the law, I can assure you that I've been in courts and heard rulings that challenges my knowledge of the law and what I teach. In other words, the fact that I tell students to know the law in one particular way or direction, and then I hear something which makes me wonder whether, what I'm telling students, whether I can still have the confidence to tell them. So this won't be the first time if that is what happened. It won't be the first time that a lawyer has a serious quarrel with a decision of a court. And that leads to the second difficulty that I mentioned, the perceptual difficulty. The special prosecutor faces a perceptual difficulty given the press conference.
No, you haven't answered my question. Should he be litigating this in press conferences and press releases criticizing the judge?
Right.
Or should be in the Court of Appeal going to the Supreme Court, so to speak?
I am exactly answering your question. And I know you'll probably take issue with that.
Okay.
But grant me this, you take that at the end.
All right.
But I'm exactly answering the question that the special prosecutor faces the perceptual difficulty, which fits into the question you're asking about.
The mandate difficulty.
How he should be doing it. Exactly. Now, the perceptual difficulty is, ordinarily, when lawyers have issues with courts, what they do is simply to take advantage of the appeal processes, to take advantage of all kinds of ancillary legal processes through motions, come before courts, challenge jurisdictions, challenge substantive issues, essentially vindicate their rights. When lawyers have issues with courts, ordinarily, they are not trained to appear before the cameras and to court the court of public opinion. And that's where the perceptual difficulty comes in. Yet, the special prosecutor is not another prosecutor. He is not a regular prosecutor, and he's even less so not a regular lawyer. He is a special prosecutor with a special mandate, a public interest defender. He is someone who is working on behalf of the public with special statutory permissions and statutory allowances. One of the statutory permissions is that the special prosecutor is allowed or enabled the opportunity of appearing before the public and giving feedback. The question then is, what is the scope of the feedback that is allowed? What is the character of that feedback? What is the degree of specificity that he should give? What is the extent to which he should particularize cases? Should he limit himself to trend analysis as he sought to do, but there were particulars? The difficulty some people may have is the particularization, the fact that there were specific cases that he mentioned. But then again, his argument could be, I do not want to speak in the abstract. I do not want to just generalize and speculate. I want to be particular so people know that there are bases to what I'm saying. But the point is what I laid out earlier, that perhaps he can be given a little flack, given the fact that he doesn't have a real template that he seems to be working with. So my sense is that he was giving the public the feedback. He may appear to have gone into some specific details, and the problem with those specific details is that they may actually even sin against a cardinal legal rule, which is the fact that matters that are sub judice, you do not publicly comment on them in terms of the degree of specificity and in terms of the particularity with which you speak on them. These are difficult tensions. And the reason
so for every matter he commented on, he had already issued a press statement. And he does it the very moment the decision is made by the courts.
Right. The point I'm making is we have an evolving scenario. That evolving scenario may appear to be in tension with certain established ways of doing things, at least from the professional standpoint. But he has statutory permissions, or he has statutory allowances under the Special Prosecutors Act, the Office of the Special Prosecutors Act. Therefore, he appears to be in a peculiar terrain. As I indicated, what the law doesn't give are the extent of details, the extent of particularity, the extent of peculiarity with which he can report. And so he's given a report which appears to be going against or being in tension with professional etiquettes and professional ways of doing things. But that's why I'm saying that perhaps he can be allowed the initial reports which we appear to be having at this stage, i.e. the fact that there are no real templates, and he may be evolving in the respect. I think moving forward, perhaps he may want to limit himself to trend analysis and the generalities of things.
But is there really a problem, as you suggest, that there may be a problem as to the extent to which he can go about what he tells the public on cases? Because Section 3, subsection 3, I think is unambiguous. It says he will do a half-yearly report. and he will publish them in at least 2 daily newspapers of national circulation and on the website of the office. And this is what he's supposed to do, the particulars. The list of corruption cases investigated and prosecuted by the office, and the number of acquittals, convictions, and cases pending in respect of the cases prosecuted, and the value of proceeds recovered. If you go to the section 31, regulation 31 of the regulations, it says publicizing detected acts of corruption.
Absolutely. Nothing you've said contradicts anything I've said. In other words, you can report. What I still maintain is the fact that the statute is still not clear on the threshold of particularities. For example, the statute says you can report on the cases, you can report on specific developments of these cases, but it doesn't speak on whether, for example, he is allowed the right of reporting on a judge's ruling on each case, even when the cases have not been completed. It's one thing to say, for example, that this case has ended and we're successful or we failed. It's another thing to say that there was a motion for X and that motion was dismissed and we disagree with the judge on that particular motion. What I indicated is that the statute is not clear on that. And given the tensions and the headwinds that are already emerging, perhaps, again, these are just reflections on moving forward. I think, for me, in the context in which I spoke on, has to do with the fact of the perceptual difficulty. There's a danger, and I'm just saying this because there's a danger some people may create the impression that he is caught in public opinion. My impression, and I've known him as Honorable Minister has said, I've known him for a very long time. He's a very capable person. He's a very, very knowledgeable person. He is totally qualified for what he's doing. I would not for a minute question his competence. The danger is that other people may. And I think the danger is people are trying to create the impression that he's moving from the court and caught in public opinion. He's actually performing a statutory obligation, but the context of the particulars, maybe he may just want to reflect on that moving forward, the extent to which certain cases are particularized, so that people do not move away from this and create a perceptual problem. And that perceptual problem is the office may be seeking to court public opinion, when indeed, in my opinion, as I indicated, he's just performing.
Thank you. Brief comments on these two. He says for a court to grant an injunction against the arrest or investigation of an individual, Charles Bissiu, the court actually issued immunity. That's literally what it is, immunity from arrest and investigation. And he was categorical that a court cannot do so.
I have to be very honest with you that I haven't really followed the detail of that, but let me take it from your report and from what you just said. I would exactly agree with him. First of all, courts do have inherent jurisdiction to do all kinds of things. So there are a lot of things that are not on statute, but the High Court has inherent jurisdiction to do them in the interest of justice. One of the things that I would not foresee a court having an inherent jurisdiction to do is to grant immunity from arrest for anybody. The Constitution has been, in an inverse way, explicit by indicating that there is only one person in Ghana who is immune from arrest, the President of Ghana. The Constitution is clear. Now, the reason I'm saying this is an inverse way is because by the principles of statutory interpretation, where there's an express statement of something, there's an implied repudiation of everything else which is not stated. Yeah. So once the Constitution has mentioned that, the rest of us are subject to the investigative authorities, to the arrest and prosecutorial authorities of Ghana, and we can all be arrested and subjected to the criminal processes at any point in time.
MPs have qualified immunity.
Well, the MPs have qualified immunity, absolutely. Again, that's another one, which is very limited. But they can't be arrested. They are not immune from arrest.
Yes.
They are procedurally immune. Yeah. So it's procedural.
Depending on where they find them.
Exactly. So
and what they are doing.
I'm not going to go into that because I know they fight me on that. I've said a few things about that.
It's a matter potentially for pronouncement.
I've said a few things about that and I've lost a few MP friends. So I won't say anything about the MP ones. But so clearly, as far as I'm concerned, the constitutional framework prohibits the courts to give anybody immunity because the Constitution has indicated the only person who is immune from the criminal process of Ghana for the period is in office.
It doesn't matter that immunity is temporary.
No.
10 days, only 10 days.
No, because if you do that, then what you have done is that you've created, within the 10 days, you've created another class of citizen in the same bracket as the president for that 10 days. I think that would be wrong. But again, that's my opinion. I'm not the court, except that from the standpoint of pure constitutional interpretation out of court.
Then to the other one, the first case that really vexed the special prosecutor, that the man is dead, so shut up.
Again, we are all being forced into, ongoing, these ongoing litigation matters and all that. Again, I restrict myself to the general principles. The truth of the matter is when a lawyer has a complaint with the court, as Professor Osai mentioned, you take advantage of the appeal processes. But it is also true that sometimes decisions challenge a lawyer's perspectives or opinion before the court, before which the lawyer pleads. And so while the lawyer has the right to exercise the option of going on appeal, indeed lawyers can also express positions as far as those particular specific rulings are concerned, because those rulings are done and over and done with, subject to appeal once if they are pending before any appellate body. It is clear, again, by the statute that the authority to investigate allows the special prosecutor to undertake certain things pending the investigation. So it will be surprising if indeed that was the outcome of the conclusion the court came to, because as far as I'm concerned, just as you read from the statute, his powers are pre-investigatory. And being pre-investigatory means the investigative process is ongoing. What the court can do is to question the necessity of particular acts. I will expect the court to stop actions of the special prosecutor on the grounds that they are not necessary.
Right.
They're either by reason of overbreadth or by reason of a lack of indexation. They are not connected to the once they are connected,
there are portions of the OSP's powers and what it's supposed to do that we may even question. That he should publish detected acts of corruption. He's detected, he should publish. Is that not prejudicial? That the law says, if you have detected acts of corruption with me, you should go ahead and publish. Is that not prejudicial?
You mean
against me?
From the statute, yes.
Yeah, that's what it says he should do.
Well, that's what I started by saying significant powers. I told you that my earlier preference was wide powers. Wide would have been negative.
Some say that's a monster we have created.
In some ways, because what it means is that...
I say you need a monster to fight the monster.
But that can be dangerous. No, that can be dangerous. You need a monster, but the monster can have unintended victims along the line.
That's why the courts are a check.
But here's the problem. The balance between reputation destroyed and reputation restored often doesn't get properly achieved in the court process. When your reputation is destroyed in the line, for example, if you publish today that Kofi Abotsi has been found to have stolen 100 million cedis, and I go to court and the court says, I haven't stolen 100 million cedis, Ghanaians already believe I've stolen 100 million cedis. I guarantee you, the fact that you even publish a rejoinder, blah, blah, blah. I mean, as far as people are concerned, these are all just, damage control, and the act has already been done. So as far as I'm concerned, when it comes to the damaging process, especially pre-investigative process, the special prosecutor should exercise some of his powers carefully.
Okay.
Because